The information provided on this show does not, and is not intended to, constitute legal advice. Instead, all information on this show is for general informational purposes only. The information provided is not a substitute for legal advice, and we recommend viewers consult an attorney for specific legal matters.
Good morning. Welcome back to Condo Craze and HOAs here on our YouTube channel. Karen Curtis and Eric Glazer, and we are happy to be here every Sunday at 11 a.m. I'm wearing an orange shirt, so I'm popping a little bit brighter than you are.
So but I understand. People see you, they don't see me. I get it.
We usually wear the same color. Yeah. Sorry. So it has nothing to do with the importance of Eric Glazer, because he's the man. He's board certified in community association law, and we are so appreciative of our sponsors. They truly offer you the best services in South Florida, including our diamond sponsor, Best Roofing. And we're here, of course, every Sunday to answer all your questions and emails about anything in the chat box, about anything making you crazy in your condo or HOA. You're board certified in community association law. There's just a handful of attorneys who are, and you have a firm here in Hollywood, Glazer and Sachs, and also one in Orlando, which you just visited. Yep. So we want to get the phone lines going early, no matter where you are. You can give us a call toll free, 717-GLAZER-8. That's with a Z, or 717-452-9378. And you can visit us again on the channel here and ask us a question in the chat box. Sometimes people do both.
So good morning, everybody. Thanks for joining us. And of course, don't forget to subscribe to two things. Number one, the Condo Craze and HOAs channel on YouTube, where you don't just have to watch the show live. You can watch any of our prior broadcasts. And of course, subscribe to our email list at condocrazeandhoas.com. By joining, you're going to get announcements about the show each week, our seminars, updates on the law, and a whole lot more. You can do that by just going to condocrazeandhoas.com to sign up. And they can find us on other social medias.
Yeah, by the way, that's Skippy back there. I didn't realize you could see her. Like the show dog. We're also on Facebook, Apple, Spotify, and LinkedIn, and X.
And of course, we do a blog every single week, and you can find that at condocrazeandhoas.com. Before we get started, I just want to say it was fantastic teaching our Condo Craze board certification class this week at the Orange County Convention Center on Wednesday. Great turnout, Karen. A lot of fans of the show in the Orlando area. It was fantastic.
They love you everywhere in this state.
They love us. They love all three of us.
Oh my gosh, and, Robert as well.
Yeah,
yes.
We haven't been there in a while, and it was really great seeing everybody. A lot of fun.
So that's it for the seminars for a while, or are you just getting started?
It will be for a little summer break here, and we're going to take some time off. But before you know it, I'm going to let everybody know about all the seminars that are already scheduled. You would not believe how many are already scheduled.
And people can sign up for them
after the summer. Rob will put them up, I guess, maybe in a week or two.
Okay.
Yeah, but they've all been scheduled. Yeah, we'll get them up there early so that people have a lot of time to sign up. But trust me when I tell you, more than ever, we will be all over the state.
Even Miami?
Yes. Oh! Even in Miami. So hang in there, Miami. Stay tuned.
Okay. So we got a call last week on the show from John, who asked you if you like your new electric Cadillac, your Lyric, right?
Yeah.
And you said you loved it.
Yeah.
But you had said, I haven't tried it on a long trip yet.
That's right.
So I heard you may have changed your mind because you took it on a long trip to Orlando, which is not that long of a trip, by the way.
Exactly. I don't even know.
It's not that. It's like 231 miles, maybe.
Right. Exactly. Yeah. About 210 was from my house to the hotel.
And you couldn't make it?
Well, we did make it, but let's. We really need to talk about this because let me remind everybody, my office drafted the statute that allows owners to install electric vehicle charging stations in their condo parking spaces. So believe me, this is relevant. But yeah, taking my electric vehicle to Orlando was an absolute disaster. If everything I said nice about having an electric vehicle last week, that's because I didn't take it on a trip outside of South Florida. It was a disaster. And let me tell you why. before we started the trip, it says that I have 350 miles, right?
Sure.
Plenty of time, right?
Golden.
It's only 210 to where we had to go. So when I got there, I should have 140 miles left over, right? I get there by the skin of my teeth. I had 29 miles left.
It lied to you.
It lied to you. So it was over 100 miles off. So the figures that the manufacturers give you, totally untrue. Yeah, maybe if you're driving the car at 50 miles an hour with the air conditioning off, that it's a true number.
It chews it up.
Other than that, obviously, it's not practical to drive in Florida without air conditioning. So forget those numbers. Throw it out.
So it's not thumbs up for electric vehicles. So you got there. Did the hotel have a charger?
The hotel did not have a charger. Okay, so let's put it this way: a disaster to even charge it up. It would have been easier to build a nuclear reactor to charge the car. You think I'm kidding? You think I'm kidding? It was disgraceful. It was ridiculous. I would pull up to a charger, right? Okay, finally you find a charger. I would get there, wouldn't work. Go to another one, wouldn't work. Go to another one, wouldn't work. So I had to keep driving around and around. Then if you found one that you think might work, and sometimes you'd go through this whole process of downloading an app and all that crap and putting in your credit card numbers and all that, and then it still wouldn't work. So you just wasted a half hour for nothing.
You couldn't go to a gas station and say, can I have a little can of electricity, please?
No, it doesn't work that way. It would be great, right? But then if you were lucky enough to get a pump to work, it cost more money to fill it up with electricity than it would have been with gasoline. And it took longer to fill up,
sure.
Even with superchargers.
No.
These BS superchargers, 10 minutes, no. 2 hours to fill up the damn car with electric. So all in all, I mean, a freaking disaster. Absolutely thumbs down. For long trips, it's disaster.
Well, your house is like 2 minutes away from work.
Yeah, you're right.
So that works for you.
Oh, yeah. If you want to go 2 blocks, it's great. It's fantastic. Right? It's thumbs up. Right. No, the bottom line is if you have where you're using it locally every day, no problem. You're staying in South Florida, even if you're driving 100 miles a day, no problem. And if you come home, you have a house, you can plug it in right outside your garage door. Fantastic. Perfect. I still love it for that. But forget about taking it out for a long trip. It is a 0. On a scale from 1 to 10, it's a 0. That's how terrible it was to take it on a trip. Do not recommend it. Rob, you had a situation
The worst is when you go on a road trip. Like, at least I took a trip to Orlando, and then you stop at these chargers, and the more cars that are charging, the slower the charging happens. So
I didn't even know that.
You pull up and it says 30 minutes, and then another car pulls up. It's then in an hour or an hour and a half. So
I mean, all this push to get the whole country driving electric cars, we're not even 10% of where we need to be. Never mind if everybody started driving an electric car. The technology is still
and the grid's not ready.
Not even close.
And don't they use coal?
The pumps aren't ready. The system we have now is simply not ready. Where if we had a few more million people driving an electric vehicle, it would be a total gridlock, total disaster. So no, at this point, we're not even close. And thumbs down on using it for anything other than local stuff. Going to work every day, no problem. Going shopping every day, no problem. Anything other than that, 0. Forget. Don't even think about it, everybody.
I bet you felt kind of vulnerable and like helpless.
You're getting nervous, like, oh my God, I'm down to 20 miles. Suppose I can't find a charging station.
And that might be lying you.
I'm going to run out of electricity completely before I even get the chance to fill it up again.
And does FDOT have like a can of electricity on their little car?
No, there's no way that if you run out of electric, that they can come to your car and with a little generator or something. Nope.
They have to put you on
They have to tow you, correct. Yeah. So, again, forget
Do you feel responsible a little bit?
Do I feel responsible? At the time, I
EV
thought
laws.
it was a good idea to promote charging stations in your condo. Now, it's better to install electric chairs than electric vehicle charging stations. Believe me, forget about it. Forget it. Believe me. All right, let's go back to the condo bill.
In all fairness, you did that because people were taking an extension cord out their upstairs window
it was
and plugging
dangerous.
their car in.
I get it.
So you made it safe.
Yeah, maybe I thought I was helping people. I'm not so sure anymore. All right, let's go back to the condo bill, House Bill 913. All right?
Yeah.
We covered a lot in the last 2 weeks.
Yeah.
So let's go back really quick. Let's go back as to what we learned so far. Karen, start us off.
Okay, so reserves can now be funded with loans or special assessments.
Right. Okay. 2, if your milestone inspection was done in the last 2 years, you can now vote to waive reserves.
If you
for
actually
up to
did
2
it.
years. Correct.
Okay.
Correct.
So experts who want to do the work to repair the condo can't have an interest in the firm that did the milestone inspection unless the relationship is disclosed.
Right. Makes sense, right?
Yes.
If the relationship isn't disclosed, the contract for services is voidable by the association.
But how to figure out if they do have an interest is up to you.
Yep. Correct. Right.
Every building official in the state has to provide lots of information to the DBPR each year about the buildings in their jurisdiction that are subject to a milestone inspection.
Okay.
Does it let them know if they have Kaufman? I guess milestone is necessary for everybody.
Yeah. There's that's true. I would argue that that's exactly right. Milestone inspection's true for everybody.
Boom.
Okay. But now let's keep going with new provisions of the bill that we haven't discussed so far. Okay. It finally defines what a video conference is.
Yeah, we had a lot of questions on that.
Right. This is good. This is good stuff. So I got to give the bill a lot of credit in this regard. So here's what the statute says about video conference. It now gets defined, and it means a real-time audio and video-based meeting between 2 or more people in different locations using video-enabled and audio-enabled devices. The notice for any meeting that will be conducted by video conference must have a hyperlink and call-in conference telephone number for owners to attend the meeting, and everybody has to understand this, and must have a physical location where unit owners can also attend the meeting in person. So even if you scheduled a Zoom meeting and you put the Zoom in instructions, you know, how to log on to that Zoom meeting, not enough. You have to have a physical location where people can actually attend. All meetings conducted by video conference must be recorded.
And that's the question was to you last week.
Right,
there were
exactly.
several people asking you.
Yes, well,
because they said, we're
define it.
doing Zoom,
Yep.
so it's not the Zoom that's recorded. The board has to do it.
The meetings have, well, I guess you can have Zoom recorded, but you better maintain a copy of it. As you'll see, and you got to put it up on your website
But the recording has to be done by the...
it has to be maintained.
So they can do Zoom.
They can do Zoom, yes. Zoom is no problem. But you have to figure out a way to, when Zoom allows you. Do you want a recording of it? Yes.
And it says now recording.
Yes, and you must maintain that recording now as an official record. But the important thing, I think, everybody knows what a video conference basically means. They understand Zoom. But people tend to think that that's enough. It's not enough. You have to have a physical location. And again, I think we all have to keep thinking of it in the scenario where there's people out there that simply don't use Zoom, simply don't use their computers.
They don't use ATMs.
Right, exactly. I don't use it. I haven't
don't.
used one. Yeah, and you got to think about that person. They have a right to go somewhere. They have a right to attend the meeting. So always think about it that way.
Especially in 55 and overs.
Absolutely.
So one of the questions, though, the guy was saying that the board wasn't in control of the Zoom, so they didn't have the recording.
That's interesting. The board better be in control of Zoom.
Okay.
The board now has to maintain a copy of that meeting if it's going to be by video conference. And it's got to go up on the website. And just audio as well, correct.
So as for board meetings, a board meeting may be conducted in person or by video conference. A board or committee member's participation in a meeting via telephone, real-time video conferencing, or similar real-time electronic or video communication counts toward a quorum. So if you got the guy on the box in the middle.
Yep, you have.
And he's not muted.
Yeah, you have 5-member board. 2 are in person at the meeting. 1 is by video conference.
You're good.
You have a quorum.
Okay,
right? You have
but
a quorum.
what if you have 2 and 1 in person?
Irrelevant.
It doesn't matter.
Yep. As long as you got 3, you're good.
They can all be on video.
They can all be on video. That's exactly right.
Okay.
But
and such a member may vote as if physically present. That's key. A speaker must be used so that the conversation of such members may be heard by the board or committee members attending in person, as well as by any unit owners present at the meeting.
Right. So needless to say, the people that are on the Zoom call, they're going to hear everything.
Sure.
But the statute is now making clear that those physically in attendance at the meeting, they need to be able to hear everything everybody is saying as well. Okay. Again, the association has an obligation to maintain a recording of all such meetings that are conducted by video conference. If there are approved minutes for a meeting held by video conference, recordings of that meeting that are conducted by video conference must be maintained for at least 1 year after the date the video recording is posted on the association's website.
Why just 1 year? Isn't it usually 7?
Well, it's going to be up on that on the website now, but the actual recording has to be maintained for 1 year. Okay.
Oh, I see.
But the recording itself for 1 year, but it'll be on the website.
Okay.
For up 7. Got it?
Got it.
Okay. So there's a lot going on with this statute. You know what? We haven't even come close. We spoke about so much, and we haven't even come close to finishing it. It's going to be several more shows. 190 page bill, yeah. So believe me, keep tuning in because there's going to be a lot that you're going to want to learn about this statute. It's monumental.
Did the governor sign it?
Not yet.
Okay.
No, not from what I understand, not yet. But so whether it's about electric cars this morning, Zoom conferences, or anything else in the condo and HOA world, give us a call here in the studio, 717-452-9378. We would love to know what you think, or drop us a question or comment in the chat box on YouTube. We'll be back right after this.
There are very large management companies, and there are very small management companies. And I think Affinity sits somewhere in the middle of that, where they are big enough to provide you with all of the back of the house services, the accounting, the infrastructure, the support systems, but small enough to be high touch.
We believe at Affinity that we do the 9 to 5 so that you don't have to do that.
Welcome back to Condo Craze and HOAs here on our YouTube channel. Karen Curtis with attorney Eric Glazer. He is board certified in community association law. That's condos, HOAs, co-ops, and there's a lot of changes going on, especially for condo owners, and we're tackling that today. And taking your calls, go ahead and give us a call, 717-GLAZER-8, and that works out to be 717-452-9378. Taking some questions from the chat.
Yeah, let's see what we got here. Lots of good mornings. Thank you, everybody. How about Naples? Yes, there will be a show in Naples. Whether or not I'm going to be doing that show, I don't know yet. But yes, there will be a show in Naples. Here's a comment. Thank heaven for Trump. I take it that's a knock to the electric car industry.
Well, that's a generational change. You can't just slam the whole country into electric cars.
Let's put, to think that by a certain date that it's going to be mandated.
35 it was.
It's silly to think that because we're not even anywhere close to that yet. Nowhere close. So,
86, the electric car.
Right. Boy, I hope that guy. Don't you want to see Comey in cuffs? I mean,
yeah,
come
but
on.
They're selling 8647 merchandise on Amazon and Etsy, and they have been.
That's terrible.
People saw it at Trump rallies. They were wearing it.
That's
it's not new.
Terrible.
Anyway.
Okay. Good chance that an electric car set fire to the Jacksonville Airport parking garage. I didn't
You're
hear.
kidding.
But is that what it was? Some big fire,
Yeah.
I guess, to take it. I didn't know.
Oh.
How they're going to enforce all this, I have no idea. Does all this apply? All the rules that we just read, does it apply to committee meetings as well? Yes, it does. It does. The recordings of committee meetings, yes, it will apply.
But not with your attorney if you're talking about something legal.
It's correct. That's exactly right. That will be attorney-client protected video. I don't even know if I would record it to begin with. When will this bill become effective? When is 9/13 effective? Assuming it becomes law, and I have every reason to assume it will become law, it will become effective July 1st, 2025.
Yep.
And isn't that far away?
No.
We're talking about a few weeks from now.
They haven't even finished. They don't have a budget.
They were coming back in June, I understand,
Yeah,
for the
after
budget.
Memorial Day. It's unbelievable.
Insane.
I've got Raul Medina, Florida HOA. I thought we'd give an HOA.
Go ahead.
Little
Go right
love.
ahead.
Can we use general proxy at the annual meeting for proxy to vote on election if quorum is obtained?
Can you use a general proxy? General proxy is generally used, or most of the time used for just to count towards a quorum. So it depends what the issue is. If I wanted to have something voted upon at the annual meeting, I would give somebody a limited proxy,
Okay.
right, to say you have the authority to vote for me if I was present on this specific issue.
Okay.
That's what I would want to use, not a general
limited,
proxy.
okay.
Yeah, correct.
All right.
Robert, we got calls?
Yep. let's go.
Okay, who do we got?
All right, our first caller, it looks like it's Sam from Tampa.
Good morning, Sam.
Yeah, good morning. I have a question regarding a closing that we have an owner that's requiring us to submit a form to sign in regards to these NOCs that are put on the title, I guess, requirement.
Okay, so are you a buyer or a seller?
A letter of sufficient funds.
Hold on, are you a buyer or a
And
seller?
They want us to sign it, but the building
Can't hear Sam.
they can go to
Sam, are you there? Sam?
Can you tell me anything about that?
Sam,
Is that required by the board? Yes.
are
Hello?
you a buyer or a seller?
Pardon me?
Are you buying or selling your unit?
I'm not my unit. I'm on the board.
You're on the
But
board.
the seller is requiring us to sign the affidavit to clear the NOC that is on the condominium from the contractor.
Okay.
We're still doing work
Yes.
on the building.
Understood. Okay, so let's explain everybody what's going on here. And when you say an NOC,
And this
an
is related to the
NOC is
hurricane.
referred to as a notice of commencement. Okay? What is a notice
Correct.
of commencement?
Correct.
It's filed by one of your contractors telling the world that, hey, we're doing work on this property. That's what a notice of commencement puts the world on notice of.
Yes, sir.
And when someone wants to sell their unit, right, to a buyer, that buyer is going to, let's say, try to get a loan. The lender is
Correct.
going to do a title search of that property, and they're going to see that there's a notice of commencement that's filed on the building by the person, by the company doing the work. So that makes the lender sit up and say, wait a minute, we want to make sure, condominium, that there's enough money that the association has on hand to pay that entity that's doing the work, so that if when the work gets done, there's no liens, there's no mechanics liens, there's no foreclosures against the building. We want to know that before we lend. So yes, it's very, very routine for the lender to say to the association, will you sign an affidavit showing that you have sufficient funds on hand to protect that entity that's doing the work? So they're going to ask you to sign what's called a sufficient funds affidavit. Routine stuff done all the time. Yes, there's no reason why you wouldn't be able to sign that, as long as you're making, as long as you can say that, yeah, there's sufficient funds on hand, or that you will pass assessments, special assessments, regular assessments, to make sure that that entity performing the work will get paid. There's no reason why you shouldn't sign that. If you don't sign it, I can tell you, it will prevent closings from going down in your community.
Oof.
Not what you want to do.
Well, okay. Well, it's the concern of the seller and the buyer wants to buy it, but again, it's interfering with the mortgage of the buyer.
That's correct.
The board
correct.
of directors in the past has not signed anything in regards to the sufficient funds signing. Our property management has also recommended you do not need to sign it.
Well,
What we have told the buyer, and you can look at the budget, it's been approved, we have the funds, but the personal financial status, we're not going to share that with a buyer.
I can tell you this: if I was a buyer, or if I was actually this, if I was a seller, and my condo association wouldn't sign a sufficient funds affidavit, saying that they have the funds on hand or that they can get the funds on hand, and you're in the middle of screwing up my closing, then yeah, I'll probably sue you for tortious interference with
And
my
the
contract.
property manager for practicing law without a license.
The manager shouldn't be telling you that. So yeah, there's language that you can put in a sufficient funds affidavit that can help the people in your community buy and sell units in their condo.
What's
and
wrong
you
with
shouldn't be. There's no reason to hold up sales for failing to sign a sufficient funds affidavit. There's absolutely no reason to do that. So I don't know what, I don't agree. And again, as Karen said, you shouldn't be taking advice from your management company in this regard. You want to take advice, take it from your counsel, not from management. Rob, next caller.
Thank you very much.
Sure thing.
Bye. Thank you.
All right. Next caller is George. I don't see where you're calling from. George, where are you calling from?
George.
Estero, Florida.
Hey, George, how are you?
Estero.
Fine. Good morning, everyone. And again, thank you for all the work you do. An HOA question. Recently, there was the Florida Statute 720 enacted with regard to architectural review committees and what they are allowed to approve or disapprove. And I don't want to go into the triple negatives of the law, but I'm looking at actually 720.3045 right now, and it has unless prohibited, okay, and then an association may not restrict, okay, unless it is totally confusing in terms of what an ARC has control of anymore in a homeowner's backyard.
Okay, so let me answer that question, George. So it says basically like unless prohibited by general law. Okay, so unless there's a county code out there, for example, right, that would prohibit a RV from being parked in someone's backyard, right? Unless there's a county provision, a local provision that would prohibit an RV from being parked in someone's backyard, for example, an architectural review committee can no longer prevent that RV from being put in somebody's backyard in an HOA if it can't be seen from the front of the home, from the home next door, from the golf course, from any other common element, right? That's what it means by unless prohibited. Because the county may still have a law out there that prohibits it.
I understand. My point is, a lot of HOAs, including mine, have an intertwined 18-hole, executive golf course, such that from my backyard, I can see almost every home, okay? And other people can see my backyard from their homes.
Right.
So given that it can be seen not only from my home, but from common grounds, and if I'm on the golf course, I can see literally everyone's backyard.
Yes, that's correct.
So
I understand
if I'm to interpret this, I can go to my
your
ARC
neighborhood's
and
easy,
say,
George.
these people can't have an umbrella. They can't have a deck chair on their backyard because I can see it. To me, that makes no sense.
George,
point.
That's exactly what the statute says. Exactly the way you're interpreting it is if things could be seen from, like I said, from the neighboring yards, like you have in your community, there are still things that the association can prohibit from an owner putting in their backyard, such as RVs,
Well, that's been
such
the
as
problem.
boats.
Because rent's so high, they're putting RVs and renting that
And
out.
renting that out. That's a totally different thing. I'm not saying
Hialeah.
you can do that.
Yeah.
And
No, they are.
But in your community, yes, the authority of the Architectural Review Committee still lives. But
Wow.
there's a lot of communities now throughout the entire state of Florida where the authority of the Architectural Review Committee has been drastically, and I mean drastically, taken away from the committee. Why? Because, again, what did the legislature hear this year? What was the theme? My HOA board, my HOA Architectural Review Committee doesn't leave me alone, doesn't get off my back. What do they care if I put something in my backyard that can't be seen? So in response to countless complaints like that, the legislature says, okay, so from now on, if something can't be seen, right, from all the places we just said, get off the owner's back. They can put all these things in their backyard. But Georgia's saying, well, everything can be seen by everybody in my community. So that law really doesn't do much effect in my community. And that's right, George, in your community, really doesn't mean much. In your community, because everybody can see everything, those things could still be prohibited. But in some committees, it's not like yours. In some committees, there's lots of homes where you put something in their backyard and nobody else can see it.
Right.
So for those instances, the law is saying, okay, leave those people alone.
Knock yourself
They're
out.
not bothering anybody.
You can put that thing they used to have at the Marlins game when they would hit a home run and the
Right. It would
can
pop
have-
up.
yeah, you can
No,
have that-
you can't see it. Who cares?
put that there.
But your community is different, George. The authority of the Architectural Review Committee lives in your community, but not in a lot of others. Okay? Hope that answers your question,
Okay,
buddy. I know, George. George is a
thank you.
long time listener
And,
of the show.
Head over to the West Coast again, because I know you laughed before when I say we have great shopping. Coconut Point Mall, Miramar Outlet Center, Gulf Coast Town Center. We have great shopping for you and your wife.
I will
So
do
come
it.
on over.
But here's what I won't do. I won't be taking an electric car. And let's take our bottom of the hour break. Taking your calls, 917-452-9378. Drop us a question or comment in the chat box. Be right back after this.
Roomkiss Consultants offer the professional expertise to help condominium and cooperative communities provide safe, compliant buildings for their tenants. We have more than 170 Florida licensed engineers and architects who are experienced with local regulations and can assist with Senate Bill 4D compliance. We can help with milestone structural inspections, capital expenditure evaluations, structural integrity reserve studies, and developer transition reports. Focusing on energy, resilience, maintainability, and sustainability, our experts can help with every phase of the building life cycle. Contact us for inspections, building restoration, repair and remediation consulting, or mitigation after a catastrophic event.
All over the world, people have plumbing problems. These problems can be expensive and destructive to fix. Have you ever wondered if there was a way to take care of your plumbing problems without destruction and an outrageous price tag? Welcome to Pipelining Technologies, Inc., where we specialize in fixing your problems without demolition and minimum cutting by means of pipelining. Pipelining is the ability to take a pipe damaged by root intrusion or long-term deterioration and make it new. By means of inserting an epoxy-saturated liner into the pipe and allowing it to harden or cure, leaving behind a brand new pipe.
That sounds great. How can I get pipelining in my home, commercial building, or condominium?
Simply fill out our online contact form and a pipelining representative will get in touch with you in a timely fashion, or call us directly at 561-853-5463.
Welcome back to Condo Craze and HOAs here on our YouTube channel. It is halfway through the hour, so don't wait to the end to give us a call and ask Attorney Eric Glazer a question about your condo, HOA. He is board certified in community association law. He's written a lot of the laws. He's probably responsible for half the stuff going on right now.
Some,
you can blame him for everything you don't like. It's his fault. 717-GLAZER-8. That's 717-452-9378. Just want to answer some questions in the chat box as well. Some people ask in the chat and then call us as well. That's Skippy back there, the show dog, by the way.
The show dog. All right, Pen 10 Cooperative writes in, can the board president hold two roles simultaneously? For example, president and treasurer. If not, where can I find this in the Florida statutes? Okay, this is for condos. Okay, so you won't find anything in the Florida statutes in this regard, whether it's the co-op statute or if it's the condo statute. These types of things you will find, however, in your bylaws of your community. Yeah, only in the bylaws. Now, it's funny that you said, can the president hold more than one position? Because oftentimes it doesn't mention anything at all about whether or not you can hold more than one officer positions. And remember, the president, vice president, secretary, treasurer, those are all officer positions. That's
and they can be decided by the board, the directors.
All right, and the board decides who's going to hold what positions in that regard. Now, sometimes you'll find, however, that when you're talking about the presidency, specifically the presidency, it'll say the president may only hold one position.
Okay.
But more often than not, it won't say anything.
Okay.
So if it doesn't prohibit somebody from holding more than one officer position, no reason why you can't.
If the documents are silent on that.
If the documents are silent on it, yeah, I would think that
President, treasurer kind of makes sense too, right?
Yeah. Oh, and here actually, person writes further on and says the docs are silent. And that's what I was at. That's why I was asking about what the statute indicates.
Okay.
It's the statute that is certainly silent in that regard. Okay. Florida HOA, can we use a general proxy? Again, general proxy is basically used to establish a quorum at the annual meeting. That's why it's very important that for both condos and HOAs, right, when that second mailing goes in the mail, oftentimes the HOAs will do the same mailing as the condos do. When that mailing goes out in the mail, you want to make sure that if you're not going to attend the annual meeting, you want to make sure that you send back your proxy. Why do you want to make sure you send back the proxy? Because even though you're not there, your proxy will count towards a quorum at the annual meeting. No quorum, you can't go through with the annual meeting. So yeah, and then it becomes a problem. The same board may roll over. You know, it all depends. And when you, depending upon which ones have Kaufman language and which ones don't have Kaufman language, even in a condo now, you may not be able to have a meeting in an election, I should say, in your condominium if you don't have a quorum. A lot of you may be saying, wait a minute, Eric, isn't it true that all we need is 20% to participate in our election and also in order to have a valid election? And the answer to that is maybe not. If you're an older condominium prior to the year 2000 and your documents require a quorum, which they do, to have an annual meeting. I know this is complicated stuff, but that statute that allows you to have an election if only 20% participate, that will not apply to you. There's an arbitration case right on point that says that new statute doesn't apply to you if you don't have as amended from time to time language, Kaufman language, and therefore you, even at your condo meeting and also in order to have an election, you're going to need a quorum. All the more reason why you want to make sure that you send back your general proxy if you can't attend the meeting because you might not even be able to have an election. Really, really important.
And that's different from the budget meeting too.
And that's totally different. Now the budget meeting, and it's a good question because a lot of boards and owners get confused by the budget meeting. A lot of owners think, well, the owners get to pass the budget. We didn't approve the budget. I'll get emails like that all the time. Eric, we didn't approve the budget. Well, who's we? The owners. The owners don't get to approve the budget. Like it or not, that's what you elected those people for, right? That's what you elected them for.
Sometimes in the general meeting, they can do the budget, right?
The budget has to be done, at least in a condo, 14 days advanced notice.
Okay.
And the budget has to be sent out, okay, in advance. And it just gets more and more and more confusing. The budget has to be sent out now showing fully funded reserves, right? And Sears reserves you can't waive, right? Sears reserves you can't waive. But what about other reserves other than Sears? Can you waive those? Yes, you can if a majority of the owners vote to waive non-Sears reserves. It used to be a majority of a quorum. Oh. Now it's a majority of everybody. There's a reason why this area of the law has now become a type of area where you can become board certified. This is complicated stuff.
It is.
I mean, people are, you try to teach it in a...
I have a headache.
Yeah, you try to teach it in a manner that everybody can understand it. But this is tough stuff. And I don't expect everybody to get it on the show in one shot, but it's tough.
And that's why you teach it as well.
That's why we teach it.
Before you started teaching it, no one was teaching it.
Yeah.
You just signed an affidavit and said, oh, I know all this stuff.
Yep, good enough, right? No?
No, you said no 15 years ago.
Let's do this. Let's take our final break of the hour. Don't save your calls for the last second. You're going to get shut out. 717-452-9378. 717-452-9378, or keep the comments coming in the chat box. We'll be back right after this.
In South Florida, the transition from bright sunshine to heavy rain and hurricanes can take a toll on your property's exterior and structural integrity. Cracked stucco, spalled concrete, they're more than eyesores. They can signal deeper issues. Now, with new Florida laws involving structural integrity requirements, we want to help you meet your milestone inspections and maintain the durability and beauty of your building. Since 2004, PD has been the trusted expert in structural concrete restoration, painting, and waterproofing for condominiums and commercial properties. Visit pd-concrete.com or call us today.
Life is full of steps. We learn to take small steps and big steps. We take steps toward adventure, to discover what's next. At South State, helping you take each step is what inspires us to keep moving forward, so you can keep enjoying what's next in your life. This is banking at its best. This is banking forward.
We are DMI Paving and Seal Coating, Florida's parking lot experts. We specialize in asphalt paving and repair, including pothole repair, seal coating using JC7 or polytar, concrete curbs, ramps, and walkways, and striping and pavement marking, as well as ADA compliance. We service commercial properties, including homeowners associations, apartment communities, shopping malls, warehouses, stadiums and arenas, and more. Experience is worth more than anything in an industry like ours, and our staff has decades of it. We have specialized equipment for any job, regardless of size, saving you time and money. DMI has a reputable history. We have been in business since 1956. We serve the state of Florida from 6 locations. Let us bid on your next parking lot project. Visit us online at dmipavingandsealcoating.com.
Welcome back to our final segment of Condo Craze and HOAs here on our YouTube channel. Karen Curtis with board-certified attorney Eric Glazer in condo law and HOA law. 717-GLAZER-8, the number to call. And also, if you have a question in the chat box, we have one from Melissa Angulo. If the owner of a condo refuses access for the 60-year recertification, what actions can the board take? Our docs allow access when necessary.
Okay, not only do the docs allow access when necessary, but the statute 718 allows access as well, and allows access during reasonable hours to prevent damage to the units, the surrounding units, the common elements, and that's exactly what those recertifications are for.
And just by law, every 30
by law,
years.
you're allowed entry. Now, I understand there's a recent case out there that says where a condo sued to get access, right? Person wouldn't let them in, and the judge said, "You already have it. Why are you suing? You're already entitled to access. So once you try that first, and see how that works out. So it's kind of premature to come here. The statute already gives you that right. So I would tell them you're coming in. and I would go in. End of story. I'd go in.
You're not,
during reasonable
the law
hours.
is on your side.
Absolutely, the law is on your side. We had a call. I think the first call of the day was about a notice of commencement that's filed by a contractor doing work in your community, putting the world on notice that they're doing the work. And there's, I guess it's Stu writes in, Stu Mia. Where does a contractor file this notice of commencement? Same place where they file the notice of lien through county records? Yes. That notice of commencement is filed in the official records, the clerk of the court, I should say, where the property is located. It becomes an official record in the county. Okay, who else we got, Rob?
All right,
county recorder's office, I should say, right?
I think the next caller is Donna from Miami.
How are you, Donna?
Hi, Eric. It's Donata.
Donata, how are you?
Greetings.
I'm good. I'm good.
Glad to hear it.
Okay, Eric. Okay, here is a great situation. So after they passed the special assessment where the contractor was supposed to be the buddy of the vice president, they came again and passed another special assessment saying that Miami-Dade made a mistake. So almost the double of the first one, almost the same amount of the first one. When I went to look, the company doesn't exist. The company that's doing the construction, that's doing what the Miami-Dade required, doesn't exist.
Why should that
Not
matter?
even
No
the
kidding.
fantasy. It doesn't exist.
So does that mean they're not licensed?
And that means that they don't exist. And you know, I'm not so good at the internet, but I had a very good friend, David Tarr, which is he's an economist. He went and checked it out for me. The company doesn't exist. Nor the fantasy number name doesn't exist either.
DBA, nothing.
Do you know if the contract is signed by anybody who may have a license of some kind, so that you can search by whether or not that person's licensed?
Look, the contract, the estimate, the document that they provided to us, it doesn't even give the address of the company. Just gives the name of a person and his telephone number.
Okay, is that person
That's
licensed? Did you see if that person has a state license of some kind?
And doing business as
Yeah,
a DBA.
exactly.
Well, it's only the first name that it's listed there. It's only the first name.
The contract is signed by somebody with just the
out-
first name? I don't understand. The contract
Just
is
the
signed by
first name.
Fred?
Yeah, they did. It doesn't have the last name.
Well,
of the
now I'm
person.
starting to get a little curious. You know, when sometimes people can't find the name of the company that they're searching for, people have a hard time finding it. I get that, and it turns out
I
that
had
the company does
economists
exist.
do that for me. But
But
listen,
if the contract is
see,
signed by
they-
someone who doesn't have a last name,
You might want to have ICE investigate that.
yeah, maybe that's true. Donata, I don't know what to tell you on this one.
Yeah.
That's kind of strange. If you'd like, get me over a copy of that contract. Let me see if I could find it for you, so that you don't go crazy. And
it was signed, so that makes it null and void.
Get me. Well, let's see
No,
before
but
we
listen,
jump to.
Eric, listen, they hate me now because I found we were paying $1,800 for the trash, collection of the trash. And I found out a contract that it was $180, and we were paying more than $1,800. So I even got threatened the other day by the president. That she said to me that if I continue writing letters to the DBPR, she's going to denounce me for fraud.
I don't know what that means, denounce you for fraud, but I can tell you this. There's a very specific statute on point right now where it makes it very clear condominiums cannot take any retaliatory conduct against any owner of a condominium for simply voicing their First Amendment rights to put in complaints with any government agency whatsoever.
You're not calling her a thief. You're just saying that there's missing what $820.
You're not calling her a thief. You're just saying that you're questioning whether or not why they're paying $1,800 a month for a contract that says $180. You're questioning as to why they're doing business with a company that doesn't exist. I think those are legitimate concerns, you know. And you certainly have every right. Now,
Eric, they broke the light. They broke the light of my car. They broke the window of my car.
We don't know that yet. I hear you.
Yeah.
Donata, let's do this. Get me a copy of that contract, and I'd be glad to look it up. Maybe I can find something you can't. But we got to move on to the next call. Thank you for a very interesting, enlightening phone call this morning.
Thank you, Eric. Thank you very much.
You got it. All right. Who else we got, Rob?
All right. Next caller is Eric.
Eric, how are you?
I'm fine. You?
All right. If nothing else, I like your first name.
I like your name too.
How can I help?
I live in a 144 unit condominium association, and I was wondering, are we required to have a reserve fund?
144 unit condominium. And so the question to that as to whether or not you need a Sears reserve fund is how tall are you?
But in Miami, he's got square footage.
That's for repairs, not for reserves. How tall are you? Not how tall are you?
6 feet.
Right, 6 feet. All right. So I made one mistake. Let it go. All right. How tall is your building?
Our building, it has 2 levels. I don't know the exact.
Okay. So stop. Hold on.
Just the first floor and second floor.
Okay. So because you're under 3 stories, under 3 stories, Sears reserves are not required. Okay.
You're good.
Now you're a perfect
example
example to talk about this, though it gets very confusing. Okay, so you're under 3 stories. Okay, so you're not required to do Sears reserves. However, you are required to send out your budget, right, with showing fully funded reserves, pavement, painting, roof, and anything else above $10,000. Pavement, painting, roof, and anything else above $10,000.
No more kicking the can.
However, they are allowed to reserve it because you're under 3 stories. That's how complicated this is. So the answer to your question, hold on, let me answer your question. So the answer to your question is yes, even though you're under 3 stories, when you send out your budget, right, that budget has to show fully funded reserves, paint, pavement, and roof. Okay, but you could waive it. All right, does that make sense?
Yeah, it does. See, here's the thing. We got hit with an $80,000 assessment each owner to repair the roof, the buildings, everything you mentioned, and we're already paying $950 a month HOA fees.
Wow.
Now the president
HOA.
said, yeah.
That's condo.
And the president said, well, once all this work is done in a year and a half, we can bring down our monthly HOA fees.
Monthly reserves. That's correct.
I don't see him doing it though.
So that's what he says is absolutely correct. So what does that mean? Once you make these massive repairs, right? So your reserves should absolutely go down.
Yeah.
Because what are you putting reserves away for? You're putting when you need to fix things, right? And it's based upon a schedule as to when you will need to fix things. So, for example, if you just put on a new roof, the amount that you're putting away now each month for the next 20 years before you need a new roof is a small amount of money. If you just waterproof the building, small amount of money because you don't need it for a long time. But if all these things are due in a year or 2 from now, you're going to be paying big money. So the gentleman, your board president is correct. Okay, if you're paying right now to fix all of these things and you have high reserves, then once you make these things and when she correct them, I should say, and you don't need to repair them until way off in the future, yes, the monthly fees should absolutely go down. Okay, yes, that makes absolutely perfect sense.
If they don't, what's our recourse?
The recourse is to do the budget correctly. If you don't like the way your board does it, then you get a different board in there. That's all I could tell you. That's your recourse.
Okay.
Okay.
I appreciate it. Thank you so much.
You got
Have a
it.
good weekend.
Last call of the day, Rob. Who do we got?
Let's go to Melissa in Bay Harbor.
How are you, Melissa?
Where's Bay Harbor?
Hey, how are you?
Okay. How can we help?
Can you guys hear me?
Sure can.
Hey, thanks so much for always enlightening the condo and homeowners associations communities.
Thank you. Thanks for
definitely
listening.
with all the changes that happened after Champlain.
Yes.
It's hard to keep up, and I feel like Tallahassee, sometimes the people making the decisions don't really understand, and they probably don't even live in condos or
Yes.
big homeowners associations.
Wait, you just said
so
something
my-
very important. What you just said is very true. After the
Yeah, no,
collapse
it's true.
of the Champlain Towers, only one representative in Tallahassee lived in a condominium, and that was Senator Pizzo. So that is correct. What you said is absolutely right.
I mean, listen, it's it's like the ones that don't commit the sin are always paying for it.
Yes.
So
How can we
it
help?
doesn't matter. And while I'm sorry.
How can we help?
So I have a situation, right? And I have this couple that bought into our association. We are small, 28 units in Bay Harbor. And they bought, maybe within a year of getting married, they bought a one-bedroom unit. Our bylaws are very clear that one-bedroom units are for two persons occupancy. And soon after, they actually solicited the board at the time out of hardship that a family member was here for asylum and could this person stay for 6 months. That was one family member, then came another.
Oh boy.
Then came the first child. Anyways, they're exceeding occupancy. We now found out that they've actually created a second bedroom within the one bedroom, which that's not the only thing that they've done. They've gone ahead and painted the hallway of their hallway where their unit is without the approval, putting paperwork or anything of the board. So I'm seeing some problems here that are concerning because we don't want to be told or is that there's allegation that we are family discrimination. These are, now they have two infants, but we also seem to, that there may be another adult. And now we know that they have actually created a second bedroom. I don't know what the recourse is anymore.
Well, that's not permitted.
This new owner, he said that he doesn't believe in the bylaws.
Okay, all right. There's that question. I could write a whole law school exam about it, quite frankly, because there's a lot there. All right, the easy one is, painting the hallway, making material alteration. Obviously, they can't do that to a common element hallway without an approval of probably 3/4 of the owners.
What color did they paint it? Did they do a mural?
No, I mean, listen, if they would have just taken white prime till we actually can make a decision, but we have so much going on. We just finished $300,000 of the roof. I can go on, but this is a disgruntled owner that basically it's like I can shove the bylaws and governing
so that's
documents
the
down their
easy
throat
one. The
all day
color
long.
one's easy, right? Where it starts to get harder is the children, okay? So the law is very clear. You can't discriminate on the basis of what's called familial status, okay? So you said there's you have a language in your documents that say a one-bedroom unit is only designed for what? Two people? Okay. So I can tell you that there's case law out there that says that is absolutely, completely unenforceable because it discriminates against families that have brand new children, right? Is in fact that there's language that allows the child to sleep in the same room with the parents.
But they've allowed two more adults in there.
Totally separate thing. I agree. Where it gets, so that's you can't discriminate against families with children. What makes your case different is that, wait a minute, we have an adult here.
2.
Okay. Well, I thought it was 1 adult
Now,
and 2 children.
Well, now she's saying that there's 2 of them making kids.
Okay.
Seeking asylum.
All right.
So there's the parent and there's the father and the mother, and then there is the habitual mother-in-law or mother-in-laws, because sometimes there's 2 of them.
Right.
And we can't really pin the button of which one is the one that's actually living here.
Right.
So you
if
know,
I
and,
was-
and this person has said, well, there's a loophole in the bylaws as far as like when it's access and when these are guests, but you know, there is no loophole.
No, you don't have to sit back and take that. I'm not telling you to sit back and take the presence of the adults. And, you know, whether or not someone's applying for asylum doesn't mean anything to me. And you don't have the right to stay in someone's home because you're applying for asylum. No, absolutely no law that I know of that suggests that.
What if the owner quit claim deeded the home, the condo, to the 2 people?
To the mother-in-laws? Or
No, to the 2 people having kids.
They couldn't do that without the association's permission.
Because they're saying there's a loophole that
I'd have to see it, but if they think they could sit back and do all of this, and they already told you what they think you can do with your governing documents, they are thinking wrong, period. You absolutely don't have to sit back and watch this. I'm sorry?
What about that they actually converted the 1 bedroom into a 2 bedroom?
And not only is guarantee you that's illegal under your condominium documents, the dividing of units, but if you told the local building official that they did that, they would be down there in a second because there has to be fireproofing between the 2 units, demising walls, and they did that illegally without permits. So I can promise you that that alone would get them in trouble with the local building official. But sitting back and letting them do all this, and with them, you know, thumbing their nose in your face, not an option. Stand up, do something about it, fight back.
What if they painted the hallway the right color? They just didn't want to wait for them to do it.
What do you
Still,
mean?
it's not a
I mean,
material alteration?
you know what? We have so many projects, right? I mean, you've been covering so many things, especially with the ongoing changes as far as like reserve requirements and so many variables that I'm telling you, you know, we often don't have the bandwidth, and I'm the board leader. And
Yeah,
I'm
but
like,
here's the
and I'm
problem.
like,
Here's
listen,
the problem.
guys, it's an issue, you know?
Well, if you let one,
Yeah.
you're going to let them all. So you really better think twice about not doing something, because the next person that you do decide to go after for doing the same things, what are they going to claim? Selective enforcement.
Yep.
So doing nothing is not an option.
And he's not the only one. I actually posted a question of another, I think, serious situation that may impact my association now with an owner that he's not here full time, but omitted and misrepresented his occupancy, and now whenever he's visiting, in another 1 bedroom, and these issues only happen with the 1 bedrooms.
Yeah, no, I hear you.
This person's now showing. This person's now showing up with the 5 children, so 7 people in a 1 bedroom unit.
Well, then I'm telling you, you cannot let that happen. Otherwise, you know, if you're going to allow that, then I'm saying this in a nice way. If you're going to allow that and you're not going to enforce it, then it's time to get off the board and walk away.
Hey, listen, I'm doing as fast as possible.
I know, but you can't allow that.
They say that I'm a dictator. They say all these
but you have documents that limit. People don't want to live in a community where everybody has the right to put 7 people in a unit. That's why your documents read the way they do. So it's your job and the board's job to enforce that. Okay. And on that note, we'll end. Okay. And hey, I appreciate everything you do for your board. I'm sure, you know, everybody does, but sometimes, you know, you got to stand up and do what you have to do. It's hard. I get it.
It's called boundaries, and you have to say no.
You have to say no, right? And if you're not the type of person that knows how to say no,
it's
difficult for you to be on the board. I get that. I get that.
It's hard.
Now, I made that unintentional joke before when I asked that guy how tall are you? I meant, how tall is your building? So somebody writes in, Michelle writes in, that's funny. How tall is Eric? Michelle, I'm 6'3.5".
That's right.
We've never met, but I'm 6'3.5". And
6'4" when he's done.
Well, I stretch out a little bit. Absolutely.
Well, there's another viewer is asking. He's 5'10". Does he need to have the SIRS.
That's very, very funny. That's, I'm nice to these people every Sunday. They're going to give me a little, that's okay, a little ribbon's
This is
fine.
hilarious.
Yeah, it's hilarious.
How tall are
Not
you?
when they go after you. Yeah, 6'3.5". Anyway, thanks for tuning in on another Sunday of Condo Craze and HOAs. If you need legal help off the air, give us a call at 954-983-1112. Again, 954-983-1112. Hey, if you want a breakdown of the new law, the new House Bill 913, just write for it. Just ask me, send me an email, eric@condo-laws.com or eric@glazersacks.com. I'd be happy to send it to you. And until next Sunday, we wish you all a very happy, healthy, and safe week. Be good, everybody. Take care.
He's 6'4" in heels.
6'4" in heels.